Welcome to my channel. I'm Harry David, and today we're diving into a fundamental topic in contract law: mistake as a vitiating element in contracts. We'll explore how mistakes can strip a contract of its binding nature and the different types of mistakes that can occur. Also, I'll be giving two essential gifts during the course of this video, one at the middle of the video and the other at the end. Let's dive in. What is mistake in contract law? In contract law, a mistake can make a contract void or voidable. This means one or both parties can be freed from their obligations if a significant mistake is identified. However, not all mistakes qualify. The law differentiates between a mistake in everyday terms and a mistake in legal terms. Mistake of fact versus mistake of law. An important distinction to be made is between mistake of fact and mistake of law. Mistake of fact occurs when parties are mistaken about a factual aspect of the contract, like believing a painting is an original when it's a replica. In Cooper versus Phibbs, 1867, the court allowed a contract to be voided due to a mistake of law. The parties were mistaken about who had the legal right to a fishery. Types of mistakes. For this video, we'll be looking at three types of mistake: common mistake, mutual mistake, unilateral mistake. Now, let's look at common mistake. A common mistake happens when both parties share the same incorrect assumption about a crucial fact. For instance, imagine buying a car that both you and the seller believe exists, only to find out it was destroyed before the sale. It is divided into residential extincta and res sua. Cases of residential extincta are those where, contrary to the parties' belief, the intended subject matter of the putative contract does not, at the time of conclusion, exist. Examples include Couturier versus Hasty. A cargo of corn was sold, but unknown to both parties. It had already been disposed of. Barrow. Lane versus Phillips Company, Ltd. A sale of nuts where some had been stolen, making the contract void due to non-existence of the goods. Res sua means one's own property in Latin. It occurs in a situation in which parties to the contract are mistaken as to the title of the goods being sold. It usually occurs when the buyer of the goods is also the owner of such property unknown to him. A good example is the case of Cooper versus Phibbs, where X wanted to buy his own fishery from Y. As I said at the beginning of the video, I'll be giving a gift. Linked in the description below, all the cases that applies to contract law has been properly reported. So instead of going to the library, just go to the description. Mutual mistake. Mutual mistake occurs when both parties misunderstand each other about a fundamental term of the contract. For example, if you think you're buying a Toyota but the seller believes they're selling a Mercedes, there's a mutual mistake. Key cases: Raffles versus Wichelhouse, a misunderstanding over which ship named Peerless was meant in the contract. Wood versus Scarth, a lease agreement where the terms were misunderstood by both parties. Unilateral mistake. In a unilateral mistake, only one party is mistaken about a fundamental aspect of the contract. If the non-mistaken party knew or should have known about the mistake, the contract might be void. Examples include Hartog versus Collin and Shields, selling goods at the wrong price per unit. King's Norton Metal Company, Ltd. versus Edridge Merrick Company, Ltd. A rogue misrepresenting identity to obtain goods. Let's look at mistake in equity. Equity steps in where common law may be too rigid. It allows contracts to be set aside if enforcing them would be unfair or cause undue hardship. Key examples: in the case of Soul versus Butcher, a lease agreement set aside due to mistaken assumptions about rent control laws. Harris versus Pepperell, a contract including land mistakenly added by the vendor. Forms of equitable relief. Number 1, rescission. Rescission allows a contract to be undone if a mistake is significant enough. This prevents one party from being unfairly burdened. Number 2, refusal of specific performance. Courts may refuse to enforce a contract if it would lead to an unjust result. This often applies where one party took advantage of the other's mistake. Number 3, rectification. Rectification adjusts the written contract to reflect what the parties actually agreed upon. It's used when a mistake is made in documenting the agreement. Now let's move to what is known as non-estate factum. Non-est factum means it is not my deed. This plea is used when someone signs a contract they were misled about, making it fundamentally different from what they intended. And a person is eligible to plead non-est factum when there's no form of negligence on their part. Examples include Foster versus Makinon, protecting signers who were deceived about the nature of the document. Adegboken versus Akinsanya, an illiterate person signing a contract misrepresented to them. Now, to the promised gift. Also, in the description there is a comprehensive note on this topic containing all the cases and exception to every general rule. In conclusion, understanding the concept of mistake in contract law is crucial for anyone involved in legal agreements. If you found this video helpful, make sure to like, subscribe, and hit the notification bell so you won't miss our next deep dive into contract law and other legal fields. Thanks for watching, and see you next time.